So when does a partner or the partnership, when does a partner of a partnership discharged from liability? So okay, a partnership or a partner is discharged from liability if the dissolution, uh, there is no really reason, or there is no uh, I mean, it does not discharge when the partnership is on the process of dissolution. It does not discharge the liability of an existing partner, no? Or the existing liability of a partner. So it only happens when there is an agreement between the partner and himself, between another partner and himself, that he is discharged, between the person or that person is discharging the liability, or and the partnership continuing the business, no? So a partner can be discharged from liability if they have agreement between the person continuing the business of the partnership and the partnership also has agreement. Number 3, a partner can be discharged of existing liability of partner if the partnership creditors agree, no? So if the partner in itself agrees, or the person who is continuing the business and the partnership agrees, or the partnership creditor agrees. So if a partnership is dissolved and it is dissolved without any contravention of the agreement, or meaning no violation of the agreement, then number 1, the apply partnership property to discharge liabilities of partnership. So the procedure here is to apply the partnership property. So if there are properties of the partnership, it should be applied to the liabilities of the partnership. Bayaran na yung utang. The number 2 is to apply the surplus, if any, to pay in cash the net amount owed to partners. So the surplus is the net, not the excess after deducting liabilities from assets. So assets minus liabilities equals the surplus. So human bayad sa liabilities from the assets, then that's the surplus. So any surplus, therefore, should be used to pay for the amount owed to partners, no? If the partners owe the partnership, I mean, if the partnership owes the partner. So if the partnership nasa utang sa kapartner, so bayaran din ng partner. That is number 2. But if the dissolution was caused by violation of the terms of the agreement, then this is the procedure in the dissolution. So first is to apply the partnership property to discharge liabilities of partnerships, so the same as the other one. Then apply the surplus, if there are any, then pay cash the net amount owed to partners. And then number 3, because there's a violation, so we're talking about damages. So indemnify for damages which is caused by the partner who is guilty of wrongful dissolution. So we pay for damages, no? So number 3, continue business in the same name during agreed term. So if there are still uncontinued business pending transactions, then the business is continued. And possess partnership property if business is continued. So these are rights of a partner, no? But if a partner is the one who causes dissolution, to the partnership. So these are the process again. So if business is not continued by the others, then the partnership properties should be used to discharge liabilities of the partnership and receive in cash its share of surplus, less damages caused by wrongful dissolution. So before the partners get their share, the surplus should be used to pay for damages, which is caused by the wrongful dissolution of the partnership. Then letter B, if the business is continued by others, then have the value of his interest at the time of dissolution. So meaning the value of the interest of the person or the partner who is guilty of wrongful dissolution of the partnership, then pay in cash and use that cash to secure the bond as bond for damages or future partnership liabilities due to the wrongful, due to the act of that partner. No? So the share of that partner's interest will not be given to the partner, but it will be used to pay for the bond. And the bond will only be released to existing and future partnership liabilities. Because for sure, the partnership will incur liabilities because of the wrongful dissolution or wrong act, or the act of the partner violating the agreement of the partnership. So what are the rights of a partner who is injured where partnership contract is rescinded on ground of fraud or misrepresentation by one party? So this time there are partners who are injured because the articles of the partnership, meaning the contract of the partnership, is rescinded or canceled. Cancelled. Why? Because there is fraud or maybe misrepresentation. You know what is misrepresentation? That's unauthorized, no? Unauthorized representation of a person or representation of a person without authority. So, ato siya panalitan o partner without authority, misrepresented the partnership. So this time other partners are injured. So what are their rights? So first right is to right to lien on surplus of partnership or partnership property after satisfying partnership liabilities. So they are given the priority to the surplus of partnership property. So again, what surplus? Assets minus liabilities. So after paying all the liabilities, they are given lien, or this lien is a charge, no? So as it is tantamount to giving them or giving the injured party priority over the surplus, over the person who is guilty of misrepresentation or guilty of fraud, no? Another right to subrogate in place of creditors after payment of partnership liabilities. So after the creditors of the partnership have been paid, then the injured partners are given the right to subrogate the place as creditors of the partnership. So they are now the creditors of the partnership, and whatever the partnership is due them, the partnership must pay. No? Number 3, the right of indemnification, meaning the right to receive for payment of damages by whom? By the guilty partner against all partnership debts and liabilities. Okay, so the guilty partner who is meaning he's guilty of fraud or misrepresentation. Fraud is deceit, no? Anikas. Now the injured partners or the injured partner has the right to be paid for damages. Against what? Against the partnership debts and liabilities. No? Okay, let's go to settlement of accounts between partnerships. This is part of the winding up process. The settlement of accounts, meaning the settlement of debts. No? So first, what are to be used in settling the debts of the assets? Of course, I've been settling the liabilities of the partnership. Of course, the assets of the partnership. So we will determine first what are the assets of the partnership. And these are the partnership properties, including goodwill. You know? So the partnership has buildings, has chairs, has a coffee shop or vehicles. Then these properties belong to the partnership. These are the assets of the partnership. And goodwill is that the name that it has created. That's goodwill. No? If it has the partnership's name has a value to other persons or has this respected name in the industry, then it is goodwill. Number 3, the contributions of the partners. So of course the partners in joining a partnership, in the creation of partnership, contributes money, industry, or property. So those contributions are assets of the partnership. So how are these assets to be applied or settled? Or are they applied? So number 1, the order of application of assets. Number 1, it should go first to partnership creditors. So these creditors are third persons, not a partner to the partnership. So another third person creditors. Okay. Number 2, partners who are creditors to the partnership. Now, in some cases, if a partnership has no more cash or lacks cash, needs cash for expansion, then one of the partners who is moneyed, the kwarta, he may lend money to the partnership. So he becomes a creditor of the partnership. So he is the second priority in the application of assets. So number 2 in the application of assets. Then we go to number 3. If there are still money or assets to be distributed, then it goes now to the partners as investors, meaning the partners' capital contribution shall be returned to them. No? Iuli ilang capital contribution. Okay? So if the partner has contributed a property worth 500,000 pesos, then he will receive 500,000 pesos. That's number 3. Now, if there are still cash or assets to be liquidated or divided after 1, 2, and 3. So number 4, the last order of application of assets is the share of profits. So this is now the surplus. So share of profits will be divided among the partners. That's the last order of application of assets. So when business of dissolved partnership is continued, so when they do that, yes, they can do that. The creditors of old partnership are also creditors of the new partnership, which continues the business of the old one without liquidation of the partnership affairs. So an old partnership could be continued by another. No? Let's say, for instance, A, B, C are partners, then C was expelled, and now they they AB agreed to continue the business, but this time the partnership's name has been changed, AB Company instead of ABC Company. So there's a new partnership, and of course, the creditors of the old partnership will become the creditors of the old or the new partnership. No, so katong creditors old partnership will become creditors of the new partnership. Number two, the creditors have an equitable lien on the consideration paid to the retiring or deceased partner by the purchaser when the retiring deceased partner sold his interest without final settlement with creditors. So number two, let's say one of the partners retired. So A, B, C, there are partners, then C decided to retire from business because he's already old, no? Or he is going to migrate to another country. So AB agreed to buy his interest. So bayaran si C, no? So in this case, the creditors have an equitable lien on the consideration paid to the retiring or deceased partner. So meaning the creditors can go after the payment made to the retiring partner, because it should have been, creditors should be given priority over, no? So if there are liabilities left unpaid by the partnership or the partners continuing the business, then they can go after the retiring or deceased partner. So the deceased partner is going to be represented by the heirs, no? Kung namatay ang isa ka partner. So let's go to the rights. If the retiring or estate of deceased partner, so this should be of. So rights of a retiring or the estate of a deceased partner. So these are his rights. If one retires from business, these are the rights of a partner. So he will have his interest appraised. So to have the value of his interest ascertained as of the date of dissolution. So that is appraising the value of his interest. So how much is now the value of my interest? No? Nag-alam di kadako ang iyang value, or could be the other way around. Nag-alam sad og kagamay. But if the business is good, then syempre, the value of his interest will increase. Then he will have the right to receive as ordinary creditor the value of his share in the dissolved partnership with interests or profits attributable to use of his right at his option. So meaning if he is not paid of his value of his share by the dissolved partnership, and the partnership is continued by a new partnership, then he will be paid interest or profits by the use of his right or his option. No? Okay, this is the last topic. So question, who are persons authorized to wind up the partnership? So firstly, there are partners designated by the agreement. So in the agreement itself, before or upon the creation of the partnership, the partners have already agreed that in case the partnership will be dissolved, and among them, they are electing persons authorized to wind up the partnership. So nag-election na sila daan. So, number two, in the absence of agreement, if they have not agreed during the execution of the partnership agreement, then those partners who are not guilty of wrongfully dissolving the partnership are authorized to wind up. Okay. So any of the partners who have not wrongfully dissolved the partnership. Number 3, their legal representative of the last surviving partner. So meaning if all the partners have died, let's say A, B, and C are partners in ABC company and they all went to the US, but unfortunately the plane they were on crashed, no? And they all died. So who will now all be authorized to wind up the partnership since all the partners are gone? Patay na silang tulo. So please answer that question. The legal representative of the last surviving partner. Okay, so that ends our topic, dissolution of partnership. For questions, you can email, write to me, masarenlod@gmail.com, or message me to my FB account at Attorney London Bank.